that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. The Supreme Court then stated that in the exercise of their wide political powers, both the county, read National Assembly, and the Senate cannot act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. End of quote. In other words, the constitutional processes are not about a dash to the finish line. They have constitutional imperatives that must be complied with, and if not, such infractions will not be out of reach of our Constitution. The timelines given in the Constitution are on the premise that its processes will comply with the constitutional requirements. Where there is an allegation that the constitutional imperatives have not been complied with, the affected person has recourse to the courts, and the court will rise to the occasion and consider whether the state organ complied with the Constitution or the law. In that respect, ours is a constitution of hope and promise that institutions established under the Constitution will comply with its fundamental principles, and the promise that the Constitution is supreme and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is out of reach of our Constitution. This is what Lord Denning had in mind when he stated many years back that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Article 2, Sub-Article 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition E522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165, Sub-Article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on costs. Thank you.
Your Honor, we seek leave to appeal the ruling.
You said you are Ogeto?
Yeah, so I know Ogeto.
Yes.
So for that reason, Your Honor, on private basis, we seek for typed proceedings and certified ruling, we are agreeable to settle any fees.
Certified copies of the ruling. Thank you. Any other counsel?
No, on behalf of the first respondent, we are only applying for a copy of the ruling.
Do you oppose their request?
Not at all. They have that.
That's Kuyone.
That's the only issue.
Along for the second respondent, it's not necessary to seek leave to appeal the decision of the High Court to the Court of Appeal, Article 164, paragraph 3 grants them an automatic right of appeal, so we are not opposing that. On behalf of the first respondent, we requesting for a copy of the ruling. Which we entirely agree with. We thank you for the well-reasoned determination.
Any other?
My order on the part of the third and fourth respondent.
That is